Actually, I wouldn't advise you to decline the invitation. I'd deal with the point. Deal with. There's nothing, more distracting than a judge who's still sitting there waiting for you to deal with the point which really troubles him. Maybe if you haven't got an answer to it, you want to keep it in the background, but otherwise try and deal with it. Be courteous. The judge keeps on coming back and saying, well, I'm sorry to keep interrupting you. No, my lord, it's extremely helpful to know what's in your lordship's mind. What you really think is, why doesn't the silly fool shut up and let me address it? Don't say that. Your lordship's very helpful to hear what your lordship has in mind. I'm going to bring this to a conclusion. I want to say two other things. And I said I would say something about arbitration. I want particularly to say that with the Akinwala Foundation here, but also because there are differences. And I think that arbitration growing, you need to know about this, particularly about international arbitration. And as India reaches out more, as it's been doing, there'll be more occasions where international arbitration will come across at your desks too, at least I hope so. Arbitration has changed. There's more cross-examination and there's more oral advocacy than there used to be. But there are still significant differences. Let me just shortly identify several of them. The first is, there's no set procedure. Generally speaking, the tribunals decide what procedure they're going to adopt. And some of the things that you regard, I regard as absolutely basic, like hearing evidence, not necessarily something they think they need to do. And if you look at the rules of the arbitral institutions like the ICC, the International Chamber of Commerce, or the London Court of International Arbitration, which now has a centre in Delhi as well, you will find that, generally speaking, their rules say they can decide, unless the parties have agreed what the procedure is. If any of you are drafting arbitration agreements, and you're very keen to have discovery, write it in the arbitration agreement, because it won't necessarily be ordered by the tribunal. So they set the rules. The second difference is there's much more written advocacy than we're used to. Not preliminary briefs, but actually the substantial argument is often set out in writing, and that is a skill. I talked a little bit about that, because often you have to spend a lot of time getting it right, but you really, really do have to follow all the other rules about being clear, being structured in order to use your signposts. Cross-examination of witnesses is not used as much. I've done international arbitrations where the idea by opponents of cross-examination is to make a speech at the witness and then put a question mark at the end of it. That's not cross-examination at all. But they are learning about it. I did a session in the International Court of, in the International Chamber of Commerce, the Court of Arbitration, with a very, very senior French advocate, and we were talking about cross-examination because it was something that they hadn't really done much of before. And he said to me, of course, in cross-examination you can't ask a leading question. And I said, I can't think of any point in asking a question in cross-examination if it isn't a leading question. He got completely the wrong idea of what cross-examination was about. So those who are experienced and learned in the common law system often have advantages. There are substantial pre-hearing, post-hearing briefs, which has become a habit which I hate, but it happens, where 3 months after the case is finished, you produce a long written document about the case. The thing to remember about that is that probably the arbitrators have forgotten everything else. Why should they remember 3 months after the event what happened, what you said? So you end up writing the whole of your case, pretending, of course, you're not doing that. The tribunal will recall. You're quite sure the tribunal don't recall, but you say that in any event. So there's a whole skill to that. And there is a different culture, because in international arbitration you are often addressing people who don't come from a common law background, who don't think as lawyers the same way that all of us in this room do. You have to bear that in mind. And it's also a less emotional experience and less aggressive. So there are different skills, but the 3 rules still apply. Be clear, preparation, and structure your arguments. When I came to consider what I was going to do after I'd been Attorney General, I had the opportunity, which is what I took, of joining an international law firm rather than going back into chambers. To some extent I wanted to do something different. The world turns in one direction, you don't go backwards. To some extent I wanted to try something different. I wanted to try global law, and if I've learnt one thing through my time in politics, in government, and at the bar, is that the world is truly a global village. We are spending more and more time involved with other countries. It's just as true, and will be just as true in Chennai as it is in London, as people do more and more business, more and more transactions, travel more and more overseas. So we do need to learn from each other. And if I have one little small criticism, I think that the Indian legal profession is being too insular. You've welcomed me very warmly today, and I'm really delighted. You've explained, Mr. Raja, about how the British barristers were capable of being discriminatory, of being arrogant, of feeling superior. And you were right to make those points, and they were wrong to adopt the attitude that they did. But the world is a smaller place, and I think the Indian legal profession can afford to be less protectionist and more inclusive. And I think it will do you good. I think that being more inclusive, learning more, experiencing more, what lawyers from other countries can do and say, ultimately will raise everybody's standard and raise the standard of justice. So that's my one small plea, is to consider that. Subject with that tiny little exception, I want to thank you very much for your very warm welcome. If there were time, I'm very happy to answer any questions if anyone would want to ask them. I think it's entirely for Mr. President to decide whether such a thing would happen. But subject to that, thank you so much for listening to me. The commander says to them, "So, men, any questions?" And one of them puts his hand up and says, "Yes, who killed JFK?" If you want to ask a question about anything which I haven't spoken about, I'm happy to deal with that too. But I don't know the answer to that question.
What was the provocation to change the House of Lords to Supreme Court? Why they, after several 100 years of practice, why did they do this?
To get bigger rooms. That's it. I mean, they were very much divided. The House of Lords has not changed its powers at all. It sounds like it's the US Supreme Court, but it's not. The powers are completely the same. The people who are appointed at the moment to the House of Lords are the same people, but they've moved from sitting in the Palace of Westminster to a building which is about 100 yards away. But they have much bigger rooms. They didn't have very much good accommodation for the judges. It's fair to say there was also a philosophical point of view that you don't want your Supreme Court to appear to be a part of Parliament. But actually, they weren't participating in the legislative business, really, in any event. So separation of powers was really there. So fundamentally, it was a matter of convenience, and that is why the members of the House of Lords were divided absolutely down the middle as to whether they wanted to do it. I was against it. At the time, I was Attorney General, and I was very worried it was going to cost a lot of money. And I cared about that because that meant that I couldn't spend that money on something else, on prosecutors.
But is that separation complete? No?
Yes, it is complete. So the latest judges who've been appointed to the Supreme Court they're not made lords, although confusingly and in a very British way, they're called lords. But in fact, the separation is different. They're no longer a member of the legislative body.
In India, the typical jurisprudence, the prosecution has to prove the case here. In America, the accused has to prove the burden of it. What is the position in England?
I think the Americans might take a different view, but let me not give you advice on American law. No, the burden of proof is very clear, with the exception of a very few specific points where the defense may have to raise the issue, or may very occasionally have to prove it, basically the prosecution has to prove the case beyond reasonable doubt. So I think the system, the standard and where the proof lies is the same.
May I ask you a question about legal regulation in your country? I understand you've moved from self-regulation to now you have, I think Ed Nally was appointed as legal commissioner. Not so much self-regulatory as imposed, probably with government sanction. And have you found that there has actually probably impacted quality or issues of ethics or pricing that you were facing initially to make that move? Do you think there has been an impact?
I mean, you raise a very good point. People are quite worried about it. You're quite right. I mean, strictly what's happened is that, in fact, the legal profession continues to be regulated by the professional bodies, the Law Society for Solicitors, the Bar Council for Barristers, the Institute of Legal Executives for Paralegals, legal executives as they're called. But there is an overarching body which has the ability to step in. It's supposed to step in only by way of default if the rulemaking is not taking place. But people are worried. You know, it's the common problem. You give people a power, they sort of use it. So far, nothing bad particularly has happened, but people are concerned about that. From the politician's point of view, of course, you say, well, look, you know, this has got to be run in the interest of the public, and if the professional bodies are not doing a job in the public interest, somebody has to be able to step in. But I think we have to watch this very, very carefully.
But we are trying to bring in a similar reform in India, and there's been a lot of protest from the legal fraternity. Was there any similar protest by the legal fraternity to this reform in UK?
I think not so much. I mean, the worry was that people who didn't understand the profession might intervene, but the danger is, and again, I don't want to make a comment about the Indian situation, you know, through ignorance, but there is always a risk with self-regulation that people are regulating in their own interests and not in the interests of the public. Keeping standards high in the interests of clients, of the public, that's very important. You've got to be careful. When I was chairman of the English Bar, you've got to be careful that what you're doing is not actually because that happens to suit lawyers best. So I wish the profession well dealing with this, but it is a very sensitive area for the reason that you've raised.
You want to know about the standard legal education in England, because there may be some views about the standards are coming down or something like that from different country to country to have this view. I want to know something about the standard legal education and the quality of the person who was passing out the law firm.
No, it's actually pretty good. I mean, I think that some senior lawyers like me, you know, we joke, not entirely, that if we were trying to get into chambers today, we wouldn't have the qualifications to do so. They're fantastic. I mean, I think the standard's very high. It's a particularly popular profession, so there's a lot of competition. The bar won't take people who don't have more degrees. They've got to have an upper second degree. They have to go through, which wasn't the way 50 years ago at least. They have to go through vocational training as well as knowing black letter law. And I think the standards are actually very high. Maybe different for other countries, but I think they're very high. You know, people have continuing education obligations, so you have to go through an academic course, you have to go through a vocational course, you then have to keep that up through having so many hours continuing professional development after you've qualified. I have to clock up 12 hours, you know, quite senior, but even so I still have to clock that up. It's not too difficult to do, but you still have to demonstrate that you're keeping your professional development up to date. I think that's right.
Just a follow-up question.
Yes, please.
Is it true that in the United Kingdom, you have senior counsel identified by a private company for the Queen's appointment?
Okay, not quite, but I know exactly where you're getting at. Queen's Counsel used to be appointed by the Lord Chancellor after having taken soundings from judges, from the Bar Council, from people. there was some concern that it wasn't right for the government to be involved in giving this sort of this seal of approval. Didn't personally agree with it, but I wasn't. It wasn't for me to decide. And so what's happened is not so much a private company, but the profession, the Bar Council and the Law Society have set up a sort of quango, a sort of body that goes through a process of appointment. The appointment is still ultimately by the Crown, you know, the Queen's Counsel. You couldn't be Queen's Counsel if it was a private company. You'd be ICC Counsel or British Telecom Council. But the standard is a process which involves a broader consultation, and the committee decides on the basis of qualifications of the individuals. So it's not a private company, it's the profession that is doing it with a degree of oversight from a public body.
Yeah. The art of advocacy. How does a lawyer deal with decided case of citations?
How does a lawyer do? Forgive me.
The decided precedents.
Yes.
When you address the court with regard to precedents or decided case in art of advocacy, could you please dwell something?
Well, obviously, you look very hard for cases which you think will win you the case, which will be helpful to you. Obviously, that's very important. Preparation involves research, look far. Maybe even look outside your own country's jurisprudence. It's quite common in England now to cite cases from other jurisdictions. If you think it's helpful, more difficult to find them. So first of all, look for cases which help you. Judges like precedent. We like to rely upon things that other people have decided before. So precedent is extremely important. That's obviously the way the common law operates. But critically, if you know of a case which is against you, you must cite it. Don't hide it. That's one of the rules of professional conduct that you really need to follow. You'll be caught out, you may be disciplined for it, but you won't be doing your client any good, and you won't be doing your future clients any good. I didn't imagine for a moment that that's something that you thought would be a good thing to do. But so my answer to your question is, find the cases which help you. If you find something which doesn't help you, then you need to cite it to the court and explain it. You may say, well, your lordship needs to see this case. You may think at first instance it's against me, but it's not, for this reason. There may be a good reason, well, it may not be such a good reason, but that's the art of advocacy, to persuade people. Can I just finally say that I really do have enjoyed being here. I can't promise to be here on your next 150th anniversary, but I'd be delighted to be here again and hope to meet some of you on that occasion. Thank you again.